The problem is not just that we need to thank the government for finding pretty large sums of money. I won't say unprecedented, because the Chancellor wrote off £13 billion of hospital trust debts, and they're standing behind £84 billion of liability to the NHS Litigation Authority. So the sums are not that enormous. All that the government is providing does one part of the cost. What's left? And the answer is twice as much for leaseholders, one way or another, and they can't afford it. In the same way that Jonathan Friedland's BBC4 programme, The Long View on the Great Fire of London, showed the impact of the fire courts and subsequent legislation, we need to go on asking government to come with us to achieve more justice for these residential leaseholders. First immediate proposal is that government under the coronavirus legislation should suspend all forfeiture of residential leaseholds and then change the law. So if a leaseholder loses their home, they at least keep the surplus equity rather than it going to the landlord. That's the first bit of justice, which is long overdue. The second one is to start asking whether the sums provided for the remediation which government haven't yet accepted responsibility for paying for can be done on undated securities that government achieve. So you only have left with an interest rate of about 1%, which takes it down for example, from 5 billion to 50 million pounds a year to fund. And all the money that will come in eventually, I believe, in damages from the cladding manufacturers, the contractors, the local building control, the national building standards, the developers, and all the rest, especially the insurance companies who stand behind the professional indemnity insurances and product insurances, can be used to pay off and repay the government for the money they've had to borrow. There is a way forward. I'd like to stop there because I think the question has been more important than my preliminary remarks. Just say thank you to all those who've helped with the progress so far. But my word, we know the progress is needed still. Thank you.
Very proud to work with the Leaseholders and our Cladding Scandal UK Cladding Action Group and a variety of other groups who've contributed to this over the years and helped ensure we are where we are. Last night, the amendment wasn't moved because when it's Lord's amendments in the Commons, only a Minister of the Crown can move amendments. So even the official opposition were not able to move any amendments. Now, the government had the opportunity to move the amendment for us to test the will of the House, but chose not to. The government had the opportunity to give us time to vote on our amendment, where I would have been able to move it myself, but chose not to. The government launched a large lobbying operation amongst our parliamentary colleagues to try and talk down any rebellion. And I'm very pleased that the majority of our colleagues held the course. And yesterday, we had colleagues phoning us by the minute saying that they were back as if an amendment was called. Sorry to inform His Lordship that the amendment will be retabled tomorrow morning in the Lords, and we will be continuing the campaign. So it looks like it will be coming back to Commons, and my parliamentary colleagues will have an opportunity to vote on it there, hopefully. In terms of the actual amendment, I don't blame the government. I'd like to work with the government. I'd like to resolve the issue for leaseholders. There's a few things we'd like to get on the record. The first one is we've never asked the taxpayer for the money. We've never asked for a bailout. All we've ever asked for is the taxpayer provides the cash flow up front so that these works can be done. Because at the moment, we know nearly 4 years after Grenfell, the reality is these works have not been getting done. So the taxpayer provides the cash up front, and there's a variety of mechanisms of doing that. Sir Peter Bottomley, Bob Blackman, Sir Bob Neal, they've all come up with lots of options that can do that. But even if the government was to just provide the funds up front and then collect the money back over the next 10 years on levies for those who are responsible, maybe at 2 billion a year for the next 10 years, the developers and building insurance and regulators, well, then we could resolve the issue once and for all. The other thing is, I think everybody says this is not the correct bill. And again, I'd like to pick His Lordship up. I'm actually proud to be chairman of the Regulatory Reform Select Committee. So I understand a little bit about regulatory reform orders. It's what I do as a select committee chairman. And this bill amends the Regulatory Reform Order Fire Safety 2005. And this bill means that it's an unintended consequence, but effectively this bill creates the power for the fire service to say to freeholders, you have to remedy these defects, and for the first time brings into scope external walls and doors, and this is where the cladding and issues come from. So this bill creates the issue, this bill creates the financial obligation on leaseholders. This is the bill that it needs to be resolved in, no other bill, because this bill is the one that amends the fire safety reform order. No other bill does that. The building safety bill won't do that. So this is the bill, we have to fix it. Now, the government could take our amendments. We hope the government tables their own amendments in lieu in the Lords to protect leaseholders. We've tried to make the amendments as wide as possible so that the government can actually work with us to resolve this issue for leaseholders. But as things currently stand, the effect of this bill is very simple. It allows a competent authority, which is the fire service, to go along to a freeholder and to quite rightly say, this building is not safe, you need to do these remediation works. That freeholder has 21 days by law to respond with a timetable of how they'll do those works. Failure to do so is a criminal offence by that freeholder. It's that serious. The freeholder then has the legal right to say that we've been directed by a competent authority to do these works, so you must pay these costs to the leaseholders, and no tribunal or court will stand in defence of the leaseholders because the freeholder has been directed by a competent authority. And that's why this bill is so important. It creates the unintended consequence of ensuring that leaseholders become responsible for making the payments. And that's why we need to get something in the bill that creates breathing room for those leaseholders, and it allows them to say, well, you know, leaseholders can be protected. They don't have to pay for historic fire safety costs. So we're not saying all maintenance costs, we're just saying historic fire safety costs. So these are the costs, for example, where, you know, you may have been in primary school when the building was built, but now you're being told that it's not safe. And who's the problem? Well, one of the other aspects is, in conjunction with the government guidance, they put a consolidated advice note out in January 2020. And instead of the guidance only applying to buildings over 18 metres, it applies to all buildings of any height. So the government, for example, could say that the guidance does not apply to buildings under 11 metres and take out hundreds of thousands of buildings at a stroke and relieve the pressure on millions of leaseholders. And then buildings over 11 metres to 18 metres are mid-rise and over 18 metres high-rise. But whether you're on 11 metres or 18 metres, you shouldn't be treated any differently. But just in summary, Mr. Chairman, the reality is this is the correct bill, because this is the bill that changes the status quo and creates the financial obligation on leaseholders to pay these costs. Thank you. Because it's this bill that creates the legal change. This bill says that leaseholders will be responsible for remediation works on external walls and doors. So the current status quo is they're not currently responsible for that. So it's this bill that creates the change. So that's why we're saying we need to deal with it in this bill. If we can't deal with it in this bill, we'll also put clauses and amendments into the building safety bill as well. But as you will know, as a very experienced parliamentarian, is we can only deal with what's in front of us. This bill is creating the legislative change. This is the only bill available to us to argue that legislative change. The building safety bill's not even being introduced to Parliament.
Stephen McPartland's analysis is correct. And if a problem is created by a bill, it ought to be resolved in the bill, is the simple approach I've found over my time of serving. The big success that the Ministry of Housing have had is in getting quite a lot of money from the Treasury. The big failure is that when this fire safety bill was being drafted, it wasn't being drafted with expert advice from people knowing what residential leaseholders' lives are like. So I don't think that the Ministry of Housing were quite on top of it while the Home Office were bringing it forward. And that's one of these things that happen in government. Trying to put things right afterwards is more difficult than building it in right in the beginning. I don't want to take up more time. I've heard my say, but basically the Stephen McPartland analysis is correct. Whether what Lord Greenhouse is saying is also correct is a separate issue. I don't want to challenge him. And I ought to actually say we wouldn't have got as far as we have without Stephen Greenhouse's actual personal interest in all this as well. So thank you, Stephen, for that.
I just want to make a very simple comment, and it's a question really, which is one of the problems that seems to have gone missing in this. And I agree I mean, a lot of this has been said by Peter Bottomley and by Stephen McPartland, and my understanding of the legislation is Stephen's right. The one comment I would make to the Minister is there is an old rule in legislative politics, a bird in the hand, and the bird in the hand in this case happens to be the bill that we're sitting at now. I'm having been in government, I have to say and Peter will recall this as well, governments become past masters at saying, just wait till the next one's coming along because you'll be able to work it all out then. And much as I love this government and trust them, I don't really. And that's the reality. I never trust the idea that there's something better coming along. This one absolutely does, as Stephen McPartland says. It changes the nature of the relationship and it puts a criminal act in the middle of this. And I think it has to be resolved. And I think the government really needs to think very carefully about this. But the point I'm making is, if we take a pace back from the leaseholders now being made deeply responsible by the freeholders, but the developers themselves have run for cover completely throughout this. And there's no way on earth that the leaseholders or even the freeholders now can get hold of the developers to find their responsibility. In one of my cases in my area, the developer actually installed cladding which was substandard at the time of its installation, and that you cannot get to them at all. And that means that there's a block. So freeholders are now finding themselves unable to take this back to the people that were responsible for this from the word go, plus all the other bits and pieces. So honestly, I just simply make this very simple point, that we're dealing here at the end of it all, at the far end, as these people who simply, for the vast, vast majority, do not have spare cash and are now facing a terrible, terrible prospect that they're going to find themselves with nothing, having done what we would encourage them to do, which is to become homeowners and through that leaseholders, etc. So I simply make that point, please get back to the government and generally say to them, we have to resolve this and we have to resolve this now.
I think the problem we have is one of timing. When the fire safety bill was going through its initial stages in the Commons, of course, we had no funding for the remediation of cladding at all. We had a small fund, 600 million, small in comparison to what we got to do the socially rented accommodation. And then we got £1 billion for private accommodation. That was clearly going to be inadequate. The Select Committee has said, it's completely inadequate to do the job. And then we've got this artificial arrangement between buildings that are 6 stories high and those that might be next door, or opposite, which are 7 or 8 stories high, where the cladding will be replaced free of charge. But the 6-story building, the leaseholders will eventually have to pay. As other colleagues have said, there's the fire safety defects. There are issues around whether the cladding is ACM, HPL, other forms of inflammable cladding. There's the issues of was this cladding illegal in the first place, which the inquiry has held that ACM cladding was illegal, in which case it's a very simple solution to me. Whoever put that cladding on in the first place is liable to pay for it to be replaced. The taxpayer shouldn't be paying for it, and neither should the leaseholders. Other forms of cladding are a bit more of a challenge. It's all a technical aspect, we know. But our biggest problem of all is that the fire safety bill is going through now. Obviously, we all want to see it enacted because there's lots of good things that flow from it. The building safety bill, as you know, Stephen, is incredibly complicated. Having sat as part of the Select Committee, gone through the pre-legislative scrutiny on the bill, we've made, I think, 40 recommendations of changes that we see need to take place to that bill before it's fit for purpose. A very long, detailed document that we've given to the ministry. Obviously, you're considering that at the moment, but we haven't had a response. Even if this bill, which I'm assuming will be announced in the Queen's speech when Parliament prorogues and we come back to the new session, it's going to take 18 months before this bill is on the statute books. We've got all the secondary legislation to go through. And in the meantime, which is the biggest problem of all, is we've created this obligation for things to be fixed. So potentially you've got 18 months to 2 years between creating the obligation and determining who would pay. Now, in the meantime, leaseholders can't sell their properties, they can't get them insured, they can't get mortgages on them. They're almost worthless if they're in this position. So there's a challenge of that 2-year period where it's going to be difficult. The industry, I mean, I've had briefings from the industry that say, you know, just doing the buildings we've got now on remediation of cladding, it's going to take 4 or 5 years. And we need the people in order to do it. So it's going to be a very long process to fix all of this. And in the meantime, the poor sucker in the middle, if I can put it this way, is the leaseholder, who is almost the person or the couple or whatever that are in the middle of all this and are living in an unsafe home. So our biggest problem, I think, is that of timing.
My question to Stephen Greenhalgh is this. Look, we all recognise that the announcement that Robert Jenrick made of the additional funds, and I know it's been a battle with the Treasury, is progress. But it doesn't solve the problem, because the government is saying we'll give you grants or loans to remove dangerous cladding from your building, depending on its height, but we're not, and Robert Jenrick made it clear in the House, we're not giving money to fix the other problems we're all very familiar with: missing fire breaks, this litany of building failures, insulation that may not be collected with cladding, timber walkways, timber balconies. And since Ian is right, and we all know this, leaseholders do not have the money. And therefore, as I said in the House yesterday, you cannot make a building half safe. And if those other problems are not remedied, and the question is who's going to pay for the remedying of them, you will be left with buildings that still can't get an EWS1 certificate, flats that are still worthless, can't be sold, waking watches still imposed by fire services because the flats will be, the blocks will be determined as being unsafe. And this will just carry on. And that is why we leave on one side whether the £50 limit a month, that is an argument where my view is I don't think leaseholders should have to pay anything because they didn't cause the problem. But at a practical level, the government says we want to fix this, but what has been announced so far doesn't fix it. And my question to you is, when are we going to see a solution that does fix it? Because when you get round to taking stuff off the building and doing work, you've got to fix all of it. You can't just fix some of it, can you?
Just go back to what the minister just said, which I completely understand, which is he said, don't assume we have all the redress measures to get all the money back, because it's complicated, of course. But the direct implication of that is that the leaseholder therefore has to foot the bill. And I think this is the challenge that we have. I think all of the conversations about which piece of legislation should this be attached to are slightly moot, because the government, I think at the moment, doesn't agree that we should pass any legislation that says that the leaseholder shouldn't pay. And I think that's the fundamental disagreement that we're struggling with at the moment. So I agree with previous speakers, Ian, Duncan, Smith and others, that you should deal with what's in front of you, which is this piece of legislation. The Building Safety Bill is months and months and months away. We can't unpick entirely at this point who is responsible and how we're going to get the payment back. So it makes sense to have a system where the payments are made up front by the government. But I think we have a fundamental problem, which is that the government don't actually agree that the leaseholder shouldn't pay some of the bill, and which is what they've accepted with the idea of having a loan. And I think there's a real worry about that loan, that they haven't scoped out at all the impact that's going to have on people's house prices and their ability to sell their flats. And I think I don't think you should introduce that without kind of understanding what the implication of it is. But the fundamental point is that by saying that basically the government is saying that leaseholders will have to foot the bill for quite a lot of this, and that's where we are. And I think we're getting slightly sidetracked by which piece of legislation it's in, because they don't agree with the current position that we're trying to push.